Welcome back to Washington Watch. My name is Joseph, back home sitting in for Tony today. So glad that you are with us. This week, one of the most significant weeks at the Supreme Court in at least a couple generations on the issue of abortion. Dobbs versus Jackson's Women's Health Clinic could be the decision that sees the overturn of Roe versus Wade and the overturn of the so-called constitutional right to an abortion that America has been living under since 1973 that has led to the death of more than 60 million children. Is this era almost over? Here to discuss that with me is Erin Hawley, senior counsel at the Alliance Defending Freedom. Erin, welcome to Washington Watch.
Thanks so much for having me. I'm glad to be here.
Well, we are glad to have you. It's been about 48 hours since oral arguments happened. We've all had a chance to kind of think about it and reflect a little bit. Has your opinion changed at all in the last 48 hours? How are you feeling?
Really good. I could not have been more pleased with oral argument. Mississippi's Solicitor General did a fantastic job. And the Supreme Court got to hear a full-throated argument to reverse Roe versus Wade for the first time in nearly 30 years. And they were really receptive. I was really pleased with the questions asked by Justice Kavanaugh, by Justices Barrett, and as the Chief Justice as well. So I think it's always so difficult to predict the Supreme Court, but all indications from oral argument were that the Supreme Court is seriously considering overturning Roe versus Wade.
And we are certainly praying for that outcome. One of the things that I appreciate about the accessibility to the Supreme Court now is it seems to be one of the few places where the best and brightest get together to actually discuss things with each other. And we get to hear the best arguments on both sides, legally and otherwise. But Justice Sotomayor had some good exchanges with Scott Stewart, the Solicitor General from the state of Mississippi. And she made an argument about the impact of abandoning their legal theory that led them to Roe versus Wade and what that might mean for other cases. I want to play that and then let you respond.
Absolutely.
Virtually every state defines a brain death as death. Yet the literature is filled with episodes of people who are completely and utterly brain dead responding to stimuli. There's about 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness.
Actually, that was a different clip, but it's also an important argument. She's comparing an unborn child to a dead person because they respond. What's she trying to say there?
So this was in response actually to an argument made by Mississippi's Solicitor General, where he explained that this one of the changes between 1973 and 1992 and today that should make it possible for the Supreme Court to overrule a prior decision is change science. And one of those changed scientific facts is that there are a significant number of doctors who are now concerned with the fact that fetuses may very well be able to feel pain. There's a number of ways they assess this. I think one interesting fact actually is that if you are a mom carrying a child, if your child is 15 weeks along and you have to undergo a certain type of procedure that might impact the child, they give that child anesthesia. And yet we allow abortions up to viability or about 22 weeks, 7 weeks later in this country, which is just crazy. But the Solicitor General was explaining that this literature explains that babies recoil when they are poked at 12 weeks, or excuse me, at 15 weeks, which indicates that they may feel pain. They also have rising cortisol levels, which indicate stress. Babies at 12 weeks, they have studies of twins in which the twins actually relate to one another. So there's this growing scientific literature that indicates that babies may well be able to feel pain as early as 12 weeks. And the Solicitor General was simply arguing that states should be able to take account of this new evidence, which led Justice Sotomayor to say, well, who cares? Because dead people can do this as well. Putting that to one side, I think it's certainly a very strong argument that state legislatures should be able to consider the possibility that babies may be able to feel pain. And that just really highlights, I think our comments highlight that this is a legislative issue, that the Constitution is silent on abortion, and the court should get out of the business of legislating abortion policy.
And I think that's the primary argument from the state of Mississippi, because from the very beginning with Roe versus Wade, it was really a legislative action. This trimester framework that they set up, then they tried to revise it with Casey in 1992. But all of this is really an attempt to create this framework that we can legislate something which is really not the job of the Supreme Court. Now, we were together at a dinner on Wednesday night. You laid out your kind of three scenarios where you thought the court might go. What are those?
Absolutely. So the first option, and the one that I very most definitely hope the court takes, is overruling, Roe versus Wade and Casey versus Planned Parenthood, the follow-along case. And I think you got a good indication on Wednesday's argument that this is the direction that a number of Supreme Court justices are leaning. Justice Kavanaugh, I know a lot of people were watching his questions, listening to his questions, because he's one of the new justices. And what Justice Kavanaugh said was, the Constitution is neither pro-choice nor pro-life. And given that fact, given that the Constitution is silent, shouldn't the court, quote, be scrupulously neutral as to abortion and return that issue to the people so that states can protect life? So this strongly indicates that he's, tired of the justices being in this position of having to legislate and create rules that are extra constitutional. So the court could go all of the way. Strike down Roe versus Wade. You'd mentioned Justice Sotomayor earlier and her concern about other cases. But the fact of the matter is that the Roe is unique among all of the Supreme Court's decisions, in that it is the only decision that has recognized a right to something that includes the right to actually kill another person. So completely different. And so I think the court will hopefully recognize that and overrule Roe. There's a couple of other options as well. The second option being one where the court kind of goes in the middle. The court could simply uphold Mississippi's law. Mississippi has a really common sense law. Yeah. It applies at 15 weeks when babies can do all sorts of things like smile and stretch and maybe feel pain.
Erin, I need to cut you off right there. We're going to continue this. We're going to let you finish the answer to that question, but we are out of time. It's a hard break. Come back. We're going to finish this conversation with Erin Hawley when we come back. Stay with us. Welcome back to Washington Watch. My name is Joseph Backholm, sitting in for Tony Perkins. Remind you that you can find this show and every segment at tonyperkins.com. We are continuing our conversation with Erin Hawley, senior counsel at the Alliance Defending Freedom, about the Dobbs decision, the case that was argued this week at the Supreme Court. And Erin, we had talked about the three potential scenarios before the break that you thought the Supreme Court had available to them. You'd gotten through about one and a half. So I'm going to let you finish that. Where is the Supreme Court going?
Right. So number one, overrule Roe. That's what we're all hoping for. Number two, simply uphold Mississippi's law. So as I was mentioning, Mississippi's law is a really common sense law. It protects life at 15 weeks. When the procedure is especially brutal, when babies can do things like smile and open and close their hands, they have all of their organs, they have a heartbeat. So the court could simply decide to uphold Mississippi's law. If you listen to the argument, this seemed to be the direction that the chief was leaning. I'm hoping he'll go further, but he mentioned numerous times that the viability line, which currently forbids states from protecting life before 22 weeks, is completely arbitrary. Even Roe's author, Justice Blackmun, recognized that the line was arbitrary. So the chief might then uphold Mississippi's law. Since the viability line is arbitrary, then he can uphold the 15-week line in Mississippi's law. So that could be a middle position the court takes. And then the third and final option that the court has would be to affirm the decision below and to find that the Constitution forbids states from protecting life prior to viability. So that would mean that Mississippi's law would fall and that states would be unable to protect life at 15 weeks or 20 weeks or anything until 22 weeks. I'm really hoping that the court doesn't do that. There's simply nothing about a right to an abortion in the Constitution's text, structure, or history. I think Mississippi made this argument really compelling on Wednesday. And it seems like a number of justices were convinced that because the Constitution is silent, this is an issue that it leaves to the people, and so that they can go before their legislatures and debate this policy issue rather than leave it to a majority of the Supreme Court.
Now, Erin, for those of us who are observers of the Supreme Court merely, we listen to oral arguments and then we stand around the proverbial Vatican for 6 months and wait for a puff of smoke to come out and tell us what has happened. You were a clerk at the Supreme Court for the Chief Justice. You've been behind the curtain. What is happening? What are they doing between now and the time that the rest of us find out what the decision is?
Absolutely. Well, today was a tremendously important day for the Dobbs case. Today, the court met in conference, and conference is a unique happening at the Supreme Court where it's only the justices. So they meet on Friday to discuss Wednesday's cases. Dobbs was on Wednesday. So they met today and they meet in the conference room. And again, it's only the justices. So they sit at this long table in order of seniority. There's actually a double door. And the idea being that, no clerk or no court reporter or nobody can come and listen to what is being said in conference, but because there's this double door and the discussions there are completely confidential. The discussion starts off with the Chief Justice laying out the facts of the case and then his view as to how it should be decided. Each justice then proceeds to explain their view of the case and what they believe should happen, ending with the most junior justice, in this case, Justice Barrett. Then they proceed to vote, again, starting with the Chief Justice all the way down to Justice Barrett. So they each have a chance to have their say. It's very orderly, usually pretty brief. And then they vote. And this is usually the first chance the justices will have had to discuss the case all together. They don't really sit down and, like you might think, and talk about the case a lot beforehand. So today's immensely important.
How much time will they dedicate to that conversation?
It really varies. I mean, it could be as little as 20 minutes, or it could go on to a couple of hours. I think in most cases, it's, probably shy of an hour. It used to be the case the justices all lived together at a boarding house in the very early days. Legend has it that the justices would sit at the dinner table and discuss cases for hours on end. And that's just not simply how it happens today. Most of the arguments that the justices have amongst one another happen in the papers and the actual drafting process.
There is this sense among some, and I will include myself in this, that when the court is going to the left, they do so fairly aggressively. Obergefell, they redefined marriage. Bostock, they redefined sex. But there's this sense that anything to the right has to be kind of measured and gradual. Is that a fair assessment? And is there any possibility that that influences what the court does in this case?
I think that a number of sort of conservative justices have this idea of sort of Burkean humility. And it's this idea that incremental changes in the law are better than giant leaps. And while that might be a perfectly good legal theory, in this case, I think for a number of reasons, it doesn't fit. As Mississippi explained so ably, Roe versus Wade is egregiously wrong. There's nothing in the Constitution that supports it. And so then you look to stare decisis factors, and which means stare decisis is this idea that a court should sort of have some sort of special reason to overrule past cases. And here they clearly exist. Not only is the decision egregiously wrong, but it harms unborn children and doesn't allow states to protect either women or children.
Erin Hawley, in about 10 seconds, how long do you think it's going to be before we find out the answer?
It'll be June. I wish it were sooner, but yeah, I would expect it would be toward the end days of June.
Then we will pray until June. Erin Hawley, Senior Counsel of the Alliance Defending Freedom, thank you so much for your time and your effort on this.
Thanks for having me.
And we will come back continuing our conversation about Dobbs, about abortion. There is a Christian case being made for abortion. Is it a good one? We'll talk about that in our Worldview segment with David Clausen when we come back right after the break. Stay with us.